All right, everyone. Welcome to another edition of Fire Law Roundup. This is Curt Varone.
Brad Pinsky.
All right, and it is January 16th of 2023. Brad, take us away.
Sure. Okay, so we're going to start with a pretty complicated topic. I'm going to try to make this as easy as possible, and then Curt, obviously for our viewers, will add a whole bunch of stuff I know on this. We're going to start in Washington State, where the states, I believe this is their highest court, the Supreme Court in for our viewers who are in New York is so screwy because our lowest court is called the Supreme Court. Our highest court is the Court of Appeal. So I never know if everyone follows the same cockamamie.
No, you guys are the only ones that do it that way. So.
That's good. So, okay, everybody else is right. In any event, so we've got to give a little legal knowledge to our viewers. This is really important. And this is a landmark holding. I mean, this is huge beyond huge for any municipality. So start with this. Normally
in Washington.
In Washington, right.
In Washington, yeah.
Which is now officially more screwed up than any other state, I think. Well,
Illinois is close, but
okay. I mean, this blew me away. I don't know how you reacted to this decision. Well, you could see you're obviously not in favor of it. No. This is insane, but who are we? We just do the reporting. So let's start with this. One of the things I always tell firefighters is listen, and public service people really is don't worry. The law protects you in 10 ways till Sunday. It is so hard to win against a municipality. And actually today is kind of municipality day in a sense. Not that it always isn't, but we have some real municipal issues today. So we'll come back and visit something like this later on. But the law protects firefighters and municipal workers with a lot of different protections. You have to file in a certain time. You have to give notices before you sue. Then you have to wait. And one of the other things, and those are big protections. And lawyers mess that up all the time to their detriment. And it helps the fire service and fire departments, et cetera. What happens here is this is true with police and fire, that there's something called the public duty doctrine. New York State has like the special duty rule, very similar. I don't know, Curt, just this phrase public duty doctrine, is that more common than special duty rule? Is it, I know a little bit different, but
it's funny. It's a relatively new principle because if you think about it historically, we had sovereign immunity up until the last century. We had sovereign immunity, which really protected government from virtually any type of suit. And then in the 50s, 60s or so, 40s, 50s, 60s, we started to see some reform, actually a little bit earlier than that, but we saw some reform and those Tort Claims Acts were enacted that made government liable. So now, with some exceptions, we still had some sovereign immunity left. We had some statutory immunity, had some other protection. But in general, government became more liable. And the problem is, I think it goes back to the common law rule, which is basically no one has a legal duty to anyone else, right? If I'm walking down the street and someone collapses, and I like to use the example, someone collapses in front of me and falls down in a puddle of water. And the puddle of water is deep enough so that it covers their mouth and nose and they're going to drown. And it's only a couple of inches deep. And I'm at absolutely no risk if I go to help them. Okay. Under the common law, no one has a legal duty to render aid to that person.
And so everyone knows common law is law that's not in a book. It developed from the court system. It developed over time. It's not in a law. It's just generally existing in that state.
Right. So the common law says no one has a legal duty to render aid. So the problem then became when government became subject to liability for negligence, when does government have a legal duty to someone? And the public duty doctrine developed as a judicial made law that essentially said that government doesn't have a legal duty to anyone. We have a public duty, we have a responsibility. Like, for example, and let's use a fire department because I think that's the best example for us. A fire department doesn't have a legal duty to get to anyone's home within 4 minutes. Now, if we get there in 4 minutes, great. If we don't, we didn't breach a legal duty, because otherwise the government becomes an insurance company that if we don't get there in 4 minutes and your house burns down, we'll just write you a check. Government isn't an insurance company. We can't guarantee things, okay? And in my state, there was a bunch of cases brought against government for things like issuing driver's licenses to people who shouldn't have had driver's licenses. And they get in an accident, the people didn't have insurance, so they're going to sue government for negligence in issue. Well, the idea here is that government doesn't owe a legal duty to everyone who could potentially be injured. So the regular principles of negligence don't apply to government unless there's some sort of a special relationship between the person who's injured and government. And that's a whole nother lecture that we could get into. But the idea here, and I want to use an example that I use in class, and I think it's a good one. Okay. And if you think about this, at 8 o'clock in the morning, Mrs. Smith's house catches fire. Okay. So 8 o'clock in the morning, we dispatch a first alarm to Mrs. Smith's house. 8:02, the first engine company is on the scene. They bang a second alarm. Okay, so now we've got 3 engines, 2 ladders, a heavy rescue, a chief, and an EMS unit on the first alarm. We duplicate that for the second alarm. Okay, 2 minutes later, the chief pulls around the corner. He bangs for a third alarm. So now we've got 9 engines, 6 ladders, all the rest of it. We get 3 alarms headed to Mrs. Smith's house. At 8:05, Mrs. Jones reports a house fire. And because we basically tapped out our entire department to Mrs. Smith's house, we don't have anybody left to go to Mrs. Jones's house. And did we breach a duty to Mrs. Jones? Because now she's waiting for mutual aid to come in, or maybe from distant, it's going to take longer. How can we provide one service to Mrs. Smith and a different service to Mrs. Jones? The way that the public duty doctrine applies there is that we didn't owe a legal duty to either one of them. And that Mrs. Jones cannot sue us because we didn't owe her a duty to get there as quickly as we did to Mrs. Smith. So that's sort of the quick thumbnail on the public duty doctrine.
And it's a perfect point to pick up because, and let me add a couple of things. So everyone understands these are negligence issues, right? This isn't for an intentional act of ours. This issues revolves around when we did something and you were injured as a result of what we did or did not do. Negligence claims. In law, we call them torts, right? And this would be an unintentional act, an unintentional tort. So this is all of these issues revolve around things we did or didn't do, as Curt said, that resulted in harm. Now, there are 4 components to negligence claims. Duty, we owed you a duty. We breached the duty to you that we owed. As a result of the breach that we owed to you, you were harmed and you do have a real harm. The problem is any one of those 4 things goes away.
And causation is the 4th. Yeah.
Oh, I'm sorry. Yeah. Approximate cause.
Duty, breach, damages, and causation.
Right. So causation being 3 are, you were harmed as a result of what we did or didn't do. Right. So if you take any one of those 4 things away, you lose the lawsuit, or the person suing you loses the lawsuit. But element number 1 is duty. So here the question is and there's a defense, right? So even if we owed you a duty, someone might say, if we breach that duty, can we be liable to you? So here, I can make this kind of simple. Curt and I have given, the viewers a long background on this. And here's what happened. The legislature said, listen, you're allowed to sue us, right? You're allowed to sue whoever we allow you to sue, right? This is what Curt was saying, sovereign immunity. The king says you can't sue me unless I tell you you can sue me. Here, right, the law says you can sue me, but enter the court now to determine, well, we're going to work this out to see what exactly you can sue us for. And here's what the court did. The public duty rule says we don't owe you a duty, right? Although we owe everybody a duty, you can't sue us for a breach of certain duties. And firefighting is, as Curt says, is a duty you owe to everybody. Police protection, we owe a duty to everybody. And generally speaking, I'm going to venture to say in many, if not most states, you cannot be liable for failing to provide a duty that you owe to everybody. The court here draws a big, bold line in that statement. What the court said is, no, not anymore. You cannot be liable, they say, if the municipality violated a duty that was provided in written state law. It was provided in statute. It was in the books. In other words, the legislature said, here's the duty you owe to somebody, and you didn't do that. You cannot be liable for violating a duty provided in statute because, I'm guessing under the reasoning of the court, listen, the state told you you had this duty, you owed it to everybody, and if you didn't reach the standard, you didn't reach the duty, right? You didn't meet that duty and do what you're supposed to, we're not going to hold you liable. But the line comes shocking to me. I mean, just lawyers, municipal lawyers like Curt and I are turning over, right? The court, highest court in Washington, and yes, again, this only applies to Washington, but this is a big deal, said, but if it's a common law duty, and we'll explain that, you can be liable. The public duty doctrine does not protect you, right? So you're protected if you violate fire department, ambulance, municipalities. You won't lose a lawsuit if the duty you're alleged to have violated is provided for in statute. So for example, if the statute says you have to give every citizen a blue crayon and you didn't give them a blue crayon, you can't be sued for that.
Let me give you an example. I'm trying to come up with a good example. Let's say it creates a statutory duty on the part of fire departments to serve as a safe haven for infants that are going to be dropped off. Okay. Yep. So in other words, what the Supreme Court of Washington is saying is if state, and I don't know if Washington state law says that. I know some states have that state law, but bottom line is if state law says fire departments have to accept delivery without question of an infant that's dropped off, and you don't do that or you do it negligently, you can't be sued.
Right.
But if it was a common law type of thing, you can be sued, which to me, it almost ought to be the opposite.
Exactly. You know, if you are watching this and you are confused, you get it, right? If you fully understand this, I think you're missing something. And to Curt's point, right? What Curt's saying is, if the legislature told you in writing you have to do something and you don't do it, you should be liable for it if you're going to create liability at all, right? But I'm almost of the belief that the way the court is viewing this is saying, look, when it's in statute, we've made it clear that everybody benefits. So since everybody, I'm making this up because I can't come up with anything. So maybe it's because everybody benefits from that statutory duty. And that's since you owe that duty to everybody, right? But here's the problem. There's no difference in law between a statutory duty and a common law duty. They're still both duties. The difference is the legislatures create, Congress, the House, Senate, whatever, create a statutory duty because they put it in a book. The courts create and have accepted and recognized, I'm going to give everyone a really good example everyone will know about, a common law duty. It's still a duty. So for example, the firefighters rule, I think is a good example, right? The firefighters rule started in most places that I'm familiar with as a common law duty. Courts created the rule that says you can't sue your fire department for an injury, or you can't sue a homeowner or somebody who causes you an injury while you're fighting fires. And then the legislature comes in and does what we call codifying the rule. They took a common law rule and they codified it. They wrote it down. It doesn't make it more or less enforceable. It's still a rule. So I'm not getting the rationale, but it doesn't matter. For those of you who live in Washington, here's something I'm challenging you to do. When you now get legal education courses, I darn well want to know, is this in statute that I have to do this? Or is this in the common law that I have to do this? And let me tell you something. I think you all should check your insurance policies. Insurance companies who insure departments, municipalities in Washington state should really be looking at their insurance policies, because all of a sudden it's going to cost a lot more to defend lawsuits. And you're going to be no more or less careful whether you're doing something that's in statute or in common law. But I'll tell you what, if it's in common law, I sure as heck want to know what that is. So if you're New York, Curt and a bunch of other lawyers always talk to me about New York law. New York has written everything down. It's all in statute, right? It's great for my business because there's so much you got to know. It's in writing. Yeah. But if I was in Washington, that would protect us because all of our duties are written down. Right. Mm-hmm. Give you a good one in West Virginia. This is a real one. In West Virginia and many other states, there are statutes on forcibly entering a building, where you have the right to forcibly enter a building to see if somebody's, there or not. Right. And so there's a lot of statutes that tell you what you can do. Well, fine. Now you forcibly enter a building. Right. And let's say Washington has that. I'm allowed to forcibly enter a building. I check on somebody. I broke their door down, broke in their house, whatever. I would be protected because it's in writing. Whereas that same act, if it's not in writing, if Washington state just recognizes that fire departments have the inherent authority, right, by their mere existence or inherent authority to break down doors to see if people are, in trouble or not. Now I hurt somebody and I'm not protected necessarily. Now, still, everyone should understand there's still 3 more elements, right? So in all our Washington state, don't panic necessarily, right? They still have to prove you breached a duty and your breach caused the injury and that they had an injury. But man, they just took away a big protection that many or most other states have not drawn this crazy distinction.
Yeah, and I know this has caused problems in a lot of states, because when you think about it, when most states that have wrestled with this have drawn it, well, not most states, excuse me. Some states that have recognized the distinction draw a distinction between the failure to act and acting negligently. Okay. And what I mean by that is a failure to act would be where a run comes in and you don't respond. Okay. You fail to act. Many states would say that the public duty doctrine applies when you fail to act. Another example would be where you fail to properly enforce the fire code. That was an issue in the Beverly Hills Supper Club fire, where they, and then allegation they failed to properly regulate the fire code issues in the Beverly Hills Supper Club. Okay. And the people who were injured were suing based on negligence, and the court said no, there was no duty. It was a public duty, not a special duty. Okay, so some states draw that distinction, and then other courts have sort of wrestled with that and say, well, how do you draw a distinction between the failure to respond, for example, and negligently responding? Because if I send you to 123 Main Street,
a case that's coming up,
it is. I send you to 123 Main Street, okay, and you go to 223 Main Street, okay. Was that a failure to respond to 123 Main Street, which obviously it was a failure to respond to you didn't get there, okay, or did you negligently respond? So you did affirmatively do something, you did it negligently. And where is the distinction between the failure to respond and negligently responding? Same thing in the Beverly Hills Supper Club fire. Did you fail to enforce the fire codes properly, or did you enforce them negligently? Right. You're splitting a hair there. And I think a lot of courts around the country have struggled with that. And that problem led Illinois to abandon the public duty doctrine entirely, which again, a couple of years ago, I covered that in the blog. I said, geez, that just opens fire departments up, because I'm not sure any other profession or any other service that government provides creates the potential for liability that we do. And certainly maybe law enforcement,
police,
law enforcement does, but you look at, we went through here in Rhode Island, the Station nightclub fire, the Beverly Hills Supper Club fire, those mass torts. I mean, I guess maybe police departments do potentially expose municipalities to some liability, but it's usually one person at a time. You don't have hundreds of people that are potentially exposed. And you look at out in California with the Wildland fires, and the allegation of negligence there against the fire department that thousands of homes or properties are damaged and everything. I just think it's, you know, I don't think the courts should be in the position of making these kinds of decisions. If anyone is going to make decisions in this area, it really ought to be the legislature, because there's,
and I suspect you're going to see the
making
legislature
decisions
step in.
they can't predict the consequence.
Right.
Okay. The court in Washington can't predict how this is going to play out. And I really think that's an indication that the legislature should be the one that is.
And I think they're going to. I am betting the you know, the whatever they call them, the municipal associations are going to cry such foul that the state legislature has got to stop it. And I don't know anything about Washington State, but you know, one would think that they will correct this.
And by the way, we haven't even mentioned the facts of this case.
No, well, interestingly, you did, because the facts of this case are simple. They dispatch 3 units apparently, but they dispatch multiple ambulances and vehicles to somebody having, I think, difficulty breathing. They go to the wrong place.
Seattle Fire Department. So it's it's a very it's a Metro Fire Department, very well respected, in particular when it comes to EMS. And I think it was a possible CPR type of response. So that's why they sent I'm assuming that's why they sent the 3 units.
3 units, which is really not overkill, but that's
it's beyond what most fire departments provide. Yeah.
Right. And they went to the wrong address because they assumed incorrectly that it was at a nursing home, and they went there delaying care, delaying intervention. Then they're like, oops.
I've done that. You're so used to going to 60 Broad Street and somebody is at 70 Broad Street. And
I can't tell you, and anybody who drives to work every day, right? So every day I'll drive the same 8 miles to work. And on the weekend, your mind's in overdrive. And I just start driving to work. I'm like, what am I doing? That's not where I'm going, right? So it's not hard. Or you know, in our town, we have East Seneca Turnpike, West Seneca Turnpike. We have East Seneca Street, West Seneca Street. All of these are possibilities, right? So the court comes in now. Listen, there may be no breach of duty here, right? Their duty was to respond. They did respond. Their duty was to respond to the right place. But is a simple error like that, is that negligence? Now, I don't know what the negligence standards they're using are. Is it gross negligence? Is it just simple, ordinary negligence? Right? There's more to this lawsuit. They don't lose just because of removing the public duty doctrine defense. But what's scary is, this is exactly the type of call that should have protected the fire department. Now, I do want to just, so everybody understands the special duty rule a little bit, that also crosses the line. The special duty rule, just like this, recognizes, listen, we owe a duty to everybody. So what's the opposite? Now, the opposite in most states, I think, I'm correct when I say most, is when you have one-on-one contact with somebody. I'll give everyone an example, and they rely on you, and they rely on your detriment, and you should have known that you told them to do something that encouraged them to rely on you. If you didn't do it, they're going to get hurt. So, for example, in one case, and in New York, this comes from a very famous case, Coffey versus City of New York. All right, and the facts. And there's a lot of these special duty cases. I handled a number of them, frankly, and I win most times by saying no duty. But here's what it is. Very simple. You get to a house fire, somebody's standing up on a balcony. This is a real case, but standing up on a balcony, and you say, don't jump, I'm coming to get you. I'll be right there. And so they don't jump, right? They stay in the room. And then I'm like, I think I'm going to go get lunch. I'll be back later. And now this is not a real case, obviously, and then I go get lunch. And the person sat there waiting for me to come get them, relied on me. It was reasonable for them to rely on me because I told them I'll be right there. And then I breached that. I don't do that. That creates, so that duty, that one-on-one relationship where they relied on me and I should have expected them to do so to their detriment, that's what creates a special duty. As opposed to, hey, the fire department got dispatched, they'll be right there, don't worry, right? The fire department doesn't really owe a duty to them. Hey, if they got lost, no big deal. They didn't have one-on-one contact.
Right, get an accident on the way, get a train
respond with the wrong equipment.
All the different things that can cause us to be delayed.
Exactly. So that's what, and look, when you have one-on-one contact with somebody and you tell them to rely on you, you've established that connection. There's a lot of cases in New York, by the way, on EMS care about, and there's no one line. It's very frustrating for me and attorneys because New York is not settled on whether an EMT who once dispatched has no obligation, no duty to that patient until they're face-to-face with the patient and they tell them to do something. It's not enough just to treat them. They normally have to tell them, okay, I'm going to do this, or we're going to do this, or we're not going to, like, we're going to wait for ALS, or we're not going to wait for ALS, right? That you have to have that one-on-one contact where they're relying on you to their detriment. And New York with EMS is all over the place. Very frustrating because I can't give you a solid rule. But fire department, mostly we're pretty well settled on, I got to tell you not to jump. Right. It's got to be one of those things. So it's a whole great hour-long course Curt and I could give you on special duty.
I think we've gone about a half hour on this
Yeah,
already.
we probably have. So I'll end with this. If you're in Washington State, I would move. No. Okay. Great wine. Great wine. No, sorry. I'm kidding, Washington State. Do not unsubscribe just because. But your court just handed you a big one. Can we do this only because it's somewhat similar? I want to jump to New Jersey. Our New Jersey case, because it's not so dissimilar in some ways. So New Jersey is, I'm going to try to make this easy. I read this last night, so I got to bring myself back up to it. But here, the Appellate Division, so the state's second highest court, not the highest court, but in New Jersey, addressed a claim by a fire captain. Now, let me explain what happened. Very simple. The fire captain was assigned two probationary firefighters on his engine, I'm assuming, because this all arises out of a hydrant and a hose. So let's assume an engine. If it was a truck company, they don't know what to do with hydrants and hoses.
They shouldn't have been anywhere near a hydrant.
Exactly. So we should have been their fault anyway. Sorry, you truckies. But this is the type of comments you get from fire lawyers. Okay. So the one of the probationary firefighters set up, sounds like, and we don't know for a fact, but sounds like he didn't get the coupling to lock. And I would have been asking, Curt and I would have been asking, was it a 2-lock coupling, a no-lock coupling, a 1-lock coupling? You know, what was it? A thread? In any event, the coupling comes off, knocks the helmet and the captain, knocks the captain in the helmet, thank God. But nonetheless, there's injuries. The lawyers for the captain are not idiots. They were impressive, right? They lose, but they're not idiots. So what the lawyers do, most people think is, well, it's a workers' comp claim. Well, the lawyers know you can't sue under workers' comp, or you can't sue because of workers' comp. All you get under workers' comp is comp. You can't sue for personal injuries that somebody caused you, at least because the workers' comp says, no, this is your exclusive remedy. You get comp. And so the lawyers got to find another way to try to sue the fire department. And what happens is, found out that many, many, many years before, the fire department, I guess they instituted a policy, but they certainly recognized that having more than one probationary firefighter on the vehicle is dangerous. So the lawyer had to find a way to say, okay, you recognize there's a danger. How can we sue under that? And what's incredible, remember, this arises out of not coupling a hydrant or a hose together, or a hose to hydrant together or something. This is not like you violated my rights under race, religion, anything like that, right? This is an injury on a scene. So what he does is he sues under a civil rights violation, right? And says, let me find the term. Let's see, there's a cause of action. As he says, there is a state created danger, right? So he alleged this is a state created danger, and you created an unreasonable danger because you put 2 probationary firefighters on my vehicle. Now, I'm going to jump to the end just so you know, and then we can just focus on the legal. The court recognizes this really wasn't so unreasonably dangerous to put 2 on, because one of them was trained enough and you liked having 2 people. And the courts do what I like the courts do, is hand you a loss with a smile. And what they did is they said, listen, Captain, You're a very good captain. You're very well qualified. You're more than qualified to take care of these two probationary firefighters on your vehicle. And you even admitted as much at deposition or trial. So it wasn't an unreasonable danger because you're more than capable, right? And I thought that was a nice way to say you lose. He said you're a highly competent captain. However, let's start looking very briefly, because this is kind of a one-off attempt that you're just not going to be able to use in your favor most times. And this is the question of the whole kind of Civil Rights Act. So here's what we have. So we have a New Jersey state law. It provides a right, a private right, for a violation of a constitutional or statutory right. And again, one of these statutory right or constitutional rights that they recognize that under the 14th Amendment, which applies the U.S. Constitution to states, that state officials cannot deprive an individual, in this case a firefighter, of life, liberty, property without due process of law. And you would say, wait a minute, how is this a due process of law violation, right? But what they said is, well, when you create an unreasonable danger, we could be depriving you, the municipality could be depriving you of a life, right? Life or liberty to be free from injury. And basically what the court comes and says, yeah, we recognize that you creating a dangerous condition could very well be depriving you of life, liberty, and property. So kudos to the lawyer, right? I think the court gives a nod to the lawyer, but then says, yeah, but this wasn't that unreasonable, right? I think if you maybe OSHA violations or, state OSHA violations, that certainly could rise. And this is what popped in my mind is now, could a firefighter sue under this deprivation of, constitutional rights to be free from injury? Could they claim that when my municipality violates a safety standard, such as an OSHA rule that's put in place, would that lead? And this is what I thought might be brilliant, because there's so many times I even have them, and I'm even thinking of my own, how do I get the municipality to comply with OSHA? I'm thinking this might be the way. So kudos to this New Jersey lawyer. You didn't have the facts on your side, but what you did to get the court to recognize a possible lawsuit or cause of action, brilliant. You get the Brad Pinsky star of approval on your lawyering. Unfortunately, you were very creative. You spent a lot of money to be this creative, and you got a good nod from the court. You just didn't have the facts on your side.
Yeah, and I think the part of the decision that really it really is where the court hung its hat was that, and I'm looking at the quote right here, that the fire department did not act with a degree of culpability that shocked the conscience. Yeah. Now I can see firefighters sitting in the firehouse saying, "Oh, that shocked the conscience,"
How dare you put two probationary firefighters on?
Right. But I think what we've got to get to the point where if it was something that truly shocked the conscience, okay, let's say you have a convicted rapist who's already raped someone and they're still on the fire department. That would be the type of thing that would shock that. You'd be like, you've got to be kidding me. Now, some people may say having two probationary firefighters shocks the conscience. I think it's got to be. I think what the court was saying, it's got to be more than that. That might have been negligent. We're not saying it's not wrongful. That we're not saying it's not stupid. Okay, we're not saying it didn't put you at risk, but it doesn't arise to the level it shocks the conscience.
Now, we will have a very shocked conscience on our last discussion when we get to Wantagh.
Yes, yes.
But let's do two easy ones before that. So in Denver, we have a lieutenant who is fired over offensive comments. Now, there's not much more to this other than, but I want to repeat some of the types of comments. But people, have this belief, I can say anything I want under free speech, and you can't fire me for that. At least in Denver, that's not the case. But here, this is a pretty federal issue. And this isn't a lawsuit. This is just, right, what you reported was he's just fired. He makes three types of comments. One that says the Holocaust never happened. Now, I got to tell you, I'm Jewish, but if you want to believe that the Holocaust never happened, okay, I don't know that I could fire you for that stupid comment, right?
You know what? When I hear people say stuff like that, I mean, certainly they have, fine, you have a First Amendment right to say it, but I think less of them. I mean, I don't feel like I have to challenge, like, really? Okay, whatever, you know?
Exactly.
You think the earth is flat? Okay, whatever.
Right.
You know?
And so and let me just say, the first two of these comments are horribly offensive, right?
Mm-hmm.
But I don't know that they justify, not that I'd want this person working for us, but it's the third one that I think crosses the free speech line. So that, understand, that's why I'm starting off with, he says the Holocaust never happened. I'm Jewish. So all the Jewish firefighters out there, and we know there's only two because your mothers would never let you do this. Speaking with hi mom. Anyway, speaking with their Jewish mother. The second one is, and this is, look, Martin Luther King Day, what a horrible day to have to say this, but he made a comment that slaves were lucky to be brought to the U.S. Obviously horribly offensive, but here's the thing. The first Holocaust thing is, okay, maybe he's just so ignorant he doesn't believe it or he's been brainwashed. Okay. The second one, slaves were lucky. You can kind of have an opinion, hey, didn't it work out well for you later? I'm not saying that, but but as an opinion, free speech doesn't cross, opinions are generally protected, right? So it's like defamation. If it's my opinion, you're an idiot. You can't sue me. You can't win for a lawsuit for defamation. But here's his third one, back to my religion here. He says, Hitler was a better person than Abraham Lincoln. Okay. Now, there is no way, in my opinion, legal opinion, to say that is not intentionally horribly offensive in such a way as to alienate your African-American community, your Jewish community, such that you just can't serve as a firefighter, right? And so the department says, look, there's no room for racism here. And these comments are just incompatible with wearing our uniform, and you're out. I agree with that. If it was only the first two comments, while they're ignorant and sensitive and stupid, I don't know whether or not that would withstand some challenges. But the last one, Hitler was a better person than Abraham Lincoln. You can't ever say somebody who killed a bunch of people, right? That's not opinion. Well, it crosses the line.
Those were the only ones listed in the article. So there may, in fact, I mean, you know as well as I do, when you do the investigation, there may in fact be additional things that weren't certainly in the news article. I tried to find a copy of the disciplinary letter or the notice of discipline to get some additional facts. I wasn't able to find it, but I'm assuming that there's more than just those three things as well.
Right. And look, I think the real interest to this article is more on the Black Lives Matter controversy, because Black Lives Matter, again, don't shoot me. This is a Martin Luther King Day, so maybe it's not the greatest time to have this, but people can say, look, Black Lives Matter, I agree with the organization or I don't. Not the message, the organization, right? So commenting on the organization is very different than commenting on the message that all Black lives matter. All lives matter, of course they do. And then you come back with, well, all lives matter, right? Well, you can't disagree with that comment, but what was the intent of the comment? And then you get the blue lives matter and the thin blue line, and right? And it starts to get to a point where the courts recognize healthy debate. They don't recognize hate speech. They don't allow hate speech. The problem is, and I'm getting way off topic, but not, is that hate speech, and by the way, the U.S. Supreme Court said hate speech is speech not only that's offensive, it's meant to intimidate somebody. For example, a noose in itself may be offensive, but that's not hate speech. I hang a noose over a black male's picture or in their locker, right? True case. Then that becomes hate speech because I used it to intimidate. So here, they're not really going on a hate speech thing. They're just saying your speech doesn't make you the type of employee we want to have, which begs the question, is that enough to terminate somebody? Mm-hmm. Right? So we don't agree that you're a Democrat. We don't agree with you're a Republican. There's certain things where you start to wonder what crosses the line. Would I terminate the person? Hell yes. But as a lawyer, is it defensible? I don't know. You might. This is right on the line.
Another thing that comes up in these cases is what's the difference between a firefighter and an officer? Because once an officer starts making these comments, and certainly as you go further up and further up in the organization, certainly when the chief makes these, imagine the fire chief making these statements. I mean,
Right. And goodbye First Amendment. Doesn't matter.
Well, the First Amendment doesn't recognize that necessary difference between a firefighter and an officer. But certainly, I think that the willingness of an organization to tolerate certain things changes with rank. And we've got to recognize that as well.
Right. Okay. And then let's do, if I didn't even have to read your blog. This is all over national news. When we go to Illinois, this is just disgusting. And if you do shit like this, well, you're going to get charged with murder. So look, I watched it. You all should watch it on the news. Police get to an individual. Let me tell you about this individual first, because the news did him justice. 18 years as a manager for McDonald's, as a manager, right? 18 years as a manager. The McDonald's Corporation recognized that this guy was good enough to manage one of their franchises, et cetera, and does so for 18 years. He is found in the home, looked a little sketchy, a bed, and it seemed a little sketchy, but the police get called for somebody acting out of character and appearing drunk, et cetera. And they're telling him calm down, and even 2 paramedics get there. And I'm going to bite my tongue on what I'd like to say, but 2 paramedics get there and are just yelling at him. They say things like, "I'm tired of this shit, get on the goddamn stretcher." And he's having trouble. They're not picking him up from what I see on the news. They're barking orders at him and yelling at him. In any event, and I don't know how the police allowed this, right? We haven't seen what the police fallout is yet, because you see the female cop and another cop, I assume, whose body cam this is, right, where it's all captured, but they're just standing by barking the same orders. And eventually the paramedics place this guy face down, hands, I think, handcuffed or strapped behind his back. He's strapped down, face into the stretcher. They suffocate the guy, right? And they all over. Look, I don't care whether he's drunk, whether he's unruly. If you need to arrest him, you arrest him. But they're taking him to the hospital. You cannot, in any state that I'm aware of, face someone basically kind of hogtied in a sense, except his feet weren't connected. But I mean, he is strapped down, covered with a blanket, face in a cot, and suffocates. I don't know there's nothing more to say. They should be charged and hopefully convicted. Interestingly to me is his ambulance employer hasn't commented yet. They should be commenting. If I'm the lawyer, right, damned them. We didn't train him to do that. We don't accept that conduct, right? Silence is going to hurt them because they're employees, and this is going to come up in our next case. Very importantly, is the employer liable for the employee? And it seems to me their silence is going to hurt them. I'd be out there saying, no way do we tolerate this. Never going to happen. You're on your own. Defend yourself in prison. But that more interesting than what happened from our point of view is really the response from the municipality. Yes, I get a tempered, let's take a breath and evaluate, but they need to come out and disavow themselves of this and say, this is not how we train people. We have a policy against it. By the way, I hope every department out there has a policy against this, right? If you can't safely transport a patient, then bring the police. But we don't hog tie them. We don't strap them down, face down, and suffocate them, right? You've got to manage an airway, and they did exactly the opposite. So I really do hope everybody reacts to this appropriately.
I just want to comment on this. I know the pressure that medics are under, that they put up with a lot of crap that a lot of times as firefighters, we don't have to put up with, or if we have to go on medical runs, we don't put up with it as long, frequently.
Right.
Okay.
And we're not trapped in the back of a box.
So I get it. I'm a big believer. I don't think people should put in a full career on an EMS unit. I really don't think that's healthy. I think they need to be rotated through there. I think that you can get burnt out. And that's sort of one point I want to make. The other one, I just was corresponding with an attorney on a case. And I think that what has happened in many places, COVID has changed the way that we respond and changed the level of supervision, because folks who act like this, I find it hard to believe this was the first time they've ever done this. Now, maybe they did it and they got away with it. It wasn't reported. But my point here is that COVID has changed the way that we, we've got another case out there, a number of other cases where firefighters have refused to transport people with COVID or talk them out of going. And so there's a bunch of cases like that. But in addition, it's put fire departments and this is an ambulance service, in a position where they can't find people that want to work. And when you can't find people that want to work, and you have people that want to work, but maybe they've engaged in some level of misconduct, maybe they're burnt, okay? Maybe we've been ordering them to work overtime, ordering them, even though they don't want to, they want to go home, we're ordering them to work. It's caused fire departments and ambulance services to change the way that they're operating. And I see a case like this, and I wonder how much of that might have been in play. Because I'm sure if we talk to these people, they would not say, yeah, we thought that this was okay. But based on what they were confronted with, their emotion at the point was that, yeah, screw you, we're going to do this. And like if you got them in a classroom, they would not say this would be okay. But yeah,
I'm not sure I agree for one different factor. And this is where I'm a little shocked. The police were there. And I think the fact that the police didn't intervene, you see them just standing there almost participating.
The police did. In fact, the family was actually very complimentary of the police, that they said that the only reason I believe that they were very complimentary. I might be thinking about another case, but because there's several cases when I go through in a given week, I might be looking at 30 or 40 cases. But
when you watch the camera, the police are just standing there and almost participating. So my fear is
here it is right here. The last paragraph in the blog: 3 Springfield police officers helped to save Moore's life as long as they could. The SPD did an awesome job. Without the body cams, we wouldn't have this information. We're so grateful they've responded the way they did.
I got to tell you, that's from what I watched on the news. I watched the female police officer standing there observing this whole thing. They all observed. They didn't, I saw, they don't look like they intervened. And in fact, it looked like they were giving because we know, right? We know since George Floyd, we know since a lot of things, you are not hog tying somebody and putting them face down, right? We're not doing that.
In a classroom, I think everybody knows that. But at 3 o'clock in the morning when this happened, when you're burnt out and you do something that you think is not going to be a problem.
Yeah, but the police were there. And I think this is going to be an interesting lawsuit, right? The police observed. What is their duty when they know,
they have
right, under their protocols, this would not be acceptable, right? And maybe they don't know EMS protocols. Maybe they think EMS protocols, maybe it is accepable, but
they've got to know about positional asphyxia. I think every police officer ought to understand about positional asphyxia.
Yeah, so I don't understand how the police didn't stop and say, wait, we're not doing this, right? Flip them over, or we'll take them, or we'll call a new ambulance. I don't know what the duty requirement is here, but here's a good example. If you're in Washington, you're in a lot of trouble, right? But the police, to me, had at least a moral duty to intervene to protect the patient from the EMTs who were intentionally harming them. I blame the police as much as I do. And look, I'm very pro-cop. This is not Brad's anti-cop. You see the cops standing there. How did this happen? I'll throw up my arms and stop there. I'd be, not that I sue police, but I'd be suing the police. If I'm somebody's lawyer and, I'd be suing the police, and suing's different than criminal, right? Criminal comes very quick, but what's criminal is not, what you might be sued for isn't necessarily criminal, but maybe the police weren't acting criminally, but they sure were culpable. They allowed this to happen. Mm-hmm. And if they're in a duty to act state, I don't think they are, right? There's only 4 or 5 of those. If they're in a duty to act state,
not. Illinois is not.
Yeah. They'd be in a lot of trouble, but I think they're in trouble. Speaking of trouble, let's go down to Long Island, where I was supposed to be tomorrow.
Not at this fire department, I hope.
Yeah. Let us start Curt and I could do an hour on this, and maybe we should. I know the attorneys who are handling or are suing on behalf of the female are actually defending a case that I'm suing on behalf of firefighters. So it's interesting. They're I don't know what their background is, but whereas I'm representing a firefighter suing somebody for harming a firefighter, they're now on my side of things representing the firefighter. In any event, this is what we have. That the facts are very simple. At least I'm going to make them simple. The facts are that there is a fire department with a firehouse with a bar. Now, for all of you career people out there or non-Long Islanders, the tradition of having bars and firehouses is a long one that is still in full force and effect. Many Long Island, not so much upstate, many Long Island firehouses still have very well functioning bars, which is a very important case. The alcohol is normally purchased by the benevolence associations, not by the fire districts. Sometimes it's purchased by the fire department recreational funds with donated funds, not taxpayer money, but sometimes it is. But these are fully functional bars, not open to the public, which matters, right? They're normally in member rooms only. They're free. You're not paying for anything. There's no bartender, usually, unless a member wants to be a bartender. As you can tell, I spend a lot of time at these bars with my clients. Not that I believe there should be bars and firehouses necessarily, but if they're there, I'm going to hang out with my clients afterwards.
Then you have Nicole to drive you home.
Yeah, exactly. Or to the nearest hotel where we normally are. So, and look, so people understand I represent a ton of the fire departments and districts down in Long Island, New York. So I don't know these people necessarily, but nonetheless, so the facts as alleged are painful. Curt has put them up. Right. We got the complaint, the lawsuit. This is
I didn't even want to put all the details up. You can read the complaint to get all the details.
Right. So I'm going to give you a very short brief. The short allegations, these are just allegations, at least in the civil part of this, is that a chief and a captain, they refer to them as employees, but I don't know why. I'm pretty sure the Wantagh Fire Department is a fully volunteer fire department and does not have a paid chief or a paid captain. But in any event, look, under fire district rules, there's a law that says all volunteers are employees. So maybe they're being, just a little loose with words. I don't think it matters for the purpose of suit. In any event, the chief and the captain are at a bar in their firehouse, and they are alleged to have given a lot of alcohol and a lot of very powerful alcohol, what they call one of them Black Death or something like that. And they are alleged to get a female volunteer significantly impaired and intoxicated with the intent, it is alleged, to take her ability to fight away. Right. So the allegation is they got her drunk so they could rape her. And they then are alleged to repeatedly rape her in a bathroom and such. The thing about firehouses are there's almost cameras in every one of these everywhere. So I'm sure the police already have the videos of this. In any event, that's the short claim. They got her intentionally drunk. They forced her to perform sexual acts upon them. They raped her, penetrated her forcibly, and there's 7 or so causes of action, everything from assault and battery to intentional infliction of emotional distress, which I have a funny comment about, to negligent infliction of emotional distress, to the Dram Shop Act. We'll talk about that a little bit. And there's other things they don't allege. Now, I'm going to be very careful, Curt. I don't want to tell you what I think they should have alleged, because I don't want to be anyone's, right? People listen to this and they know me, and I don't want to be handing somebody some additional reasons.
But they missed some issues. I think that's what you're saying.
They definitely missed some legal issues. Now, understand the thought of the lawyer. Like we gave kudos to the lawyer here. These people, the chief and the captain, probably don't have the multi-millions of dollars that the department does. And I don't know whether Wantagh is a fire district. I thought it was, but they sued the fire.
They sued both the district and the department.
Okay. Yeah. So the district is a municipality. The department's a not-for-profit corporation. It is going to matter. But was there an Inc. on the end? Wantagh Fire Department, Inc.
I have to go through the complaint.
Yeah, and maybe it's getting too hyper-technical, but it matters because remember where I started this, who provided the alcohol, right? The building presumably is owned by the district, but what a lot of these places do is they have, and again, I'm trying to be cautious because I'm not trying to help out any lawyer on one side or the other, because I would have done this much differently. But the most likely it's the corporation who provided the alcohol and manages the bar. And some of my clients, we get the bar spun off to the benevolent, so it's not the district or the department.
Brad, paragraph 2 of the complaint says that at all relevant times, the defendant, Wantagh Fire Department, was and is a municipal fire department corporation, organized and existing under the laws of the state of New York.
Yeah,
so
these
I'm not sure
lawyers don't get it.
Yeah.
These lawyers are, and I don't want to say too much. I'm not trying to help or hurt anybody, but the lawyers are missing a lot. And I'm going to kind of end that part of the comment there. But what Curt and I, or you and I really want to talk about, look, rape is rape, right? That doesn't need anything, any discussion. But on a liability question, I also don't think this is dram shop. Let me explain to everyone what dram shop is. Dram shop, it's not a New York only type thing. Basically, it's you go to a bar, they serve you too much alcohol, you go out and you, let's say, kill somebody with your car, you get into an accident, that the person who is hit with the car by the drunk driver can sue the bar for knowingly allowing someone to be intoxicated and then drive, right? Same type of theory here. You knowingly allowed someone to get intoxicated, but that's what dram shop is. Here, they use, allegedly, alcohol as a weapon, right? And no different than dropping something in your drink to take away your willpower, to paralyze you effectively. They use alcohol as a weapon. She will argue, to get them drunk. So that's not really dram shop, in my opinion, but you could do whatever you want. I'm not going to comment too much more on that, but understand what's happening here. The lawyer is trying to find a way to get to the insurance policy, or it doesn't matter, the money of the district. Now, the district is a municipality. As Judge Cardozo or somebody said, the municipality is not broke until every last taxpayer is broke. I'm kind of changing that. It's corporation and shareholder.
I like Judge Cardozo.
Yeah, same type of thing, right? And he's got a law school named after him now, as he should. But nonetheless, the laws with districts, look, they're tax-paying entities and they can lose a lawsuit and will have to raise money that the taxpayers will have to pay. So it doesn't matter whether this is insured or not. But here's the thing, you've got to get the district on the hook. So their question is, what did the district do that allowed it? Now, vicarious liability, right, is the chief, who is an employee for at least statutory purposes, right? Because town law 174 says that all volunteers are employees of the district. They do that for liability purposes so that the district is liable for the acts of the employee. Now, insurance is going to get out of this quickly. Probably. Insurance will try to get it out of quickly, saying, listen, these are intentional acts. We don't cover you. Probably true. Unless the lawyer can try to get the bar, the dram shop type, right? I don't even think you need dram shop. I think they could have said something like a dangerous condition, unsupervised, lack of training, all that stuff, having a bar. I don't want to go too much down that road. But they got to find a way to get the employer, the district, liable for the employee's acts, intentional acts. And interestingly enough, about 2 weeks ago, you and I were here talking, and I said, when I worked in the court system, I had a case where a state trooper at a park who was assigned to patrol the park raped a female while on duty. And we, the court, kicked the case out, saying it was not his job duty to rape anybody. So the vicarious liability and the liability of the state was very easily disposed of, got thrown out. And there's probably a lot of cases like that, but that's the one that sticks out of my mind. And we just talked about it 2 or 3 weeks ago. So I think it is going to be very difficult to get the district, as at least a legal matter, maybe not a practical public outcry matter. It's not going to be difficult. It is going to be difficult to get the district to pay, at least on that theory.
But let's because I think folks can learn something here. What would be the types of things? Because if I was the attorney here, I'd be looking for a way to say the fire department should have been aware that this kind of stuff was happening, and that they've had complaints in the past, and that they made the complaints go away, they didn't investigate, and that they were negligent in terms of not putting the kibosh on this kind of behavior.
And if the lawyer was listening to what we just talked about with the civil rights violation, with the coupling, is this now the same type of case, right? Due process violation. Yes, that was under a New Jersey act, but New York got some similar things, right? It all comes from the 14th Amendment. Was this a heightened danger? Was alcohol in the firehouse a heightened danger they should have known about? They could throw that out.
So a Monell kind of a possibility. But I think you could go for negligent supervision, negligent retention, and that aspect as well. And then fine, you got your dram shop aspect. But here's my point, and the point I really want to have the folks take away is that when you have an allegation that something might have occurred, you have to investigate it. I find it hard to believe that we'd have this kind of thing happen and there was no warning in earlier cases that things that maybe not this bad, but things weren't happening. You know, I'm a little suspicious when I see a major allegation like this, and we didn't have any inkling that we were having some problems.
Again, so our viewers understand, assuming that the facts as alleged are true, right? Absolutely. It would be hard to imagine that there's been no prior alcohol infractions. Now, rising to this level, hard to imagine.
Maybe not. But again, it points to the importance of when a department and the department's leadership, and in this case, the chief was involved, but we're talking about everybody has bosses. Other than at the Pinsky law firm and the Verone law firm, we're the bosses, but everybody, if you're a fire chief, you have bosses. And when a complaint comes in, that these things need to be investigated, not to try to get somebody, but to try to figure out what happened and what are the problems, and we need to take affirmative steps to make sure this kind of stuff doesn't continue.
Right. And you know, I said I wasn't going to do this, but I'll do a little bit. There's one of the liabilities for alcohol is landowner duties to provide a safe place, right? Not discussed here to my review of it, but the landowner has a duty. Bars have a duty to provide a safe place. I have a case like this now in the Bronx that I'm defending a bar in. But, you know, landowners in New York have a duty to provide a safe place and a heightened duty when they know of past activity, or such as past criminal activity. They have a heightened duty. So a landowner has liability just by owning a building and owes its occupants and residents a certain duty. I think that's missed here, but nonetheless, if you, a fire department, still have a bar, or you allow dangerous activities at your firehouse, and you don't properly correct and supervise, right, as Curt's saying, you may find that you're in hot water. If this had happened, exact circumstances happened at a private bar, just because they were the chief or the captain, probably there would never be a liability like this. The problem is that it happened at a bar in the firehouse, allegedly, and that's what potentially is getting them in hot water.
All right. Well, that was a tough week. And I got to tell you, there was at least 5 or 6 other cases this week that I really, each night I was like, which one should I blog about? There was a lot of activity. I don't know, maybe things earlier in the year kind of, you know, the courts didn't make decisions or people didn't file lawsuits. And boy, there was quite a few. And I'll list some of them. I got a newsletter going out tomorrow that'll list some of those other headline cases, but just
these are emotionally draining. I got to tell you, I mean, for us, where we try to not look at, you know, the facts, we try to look at the law and we don't judge necessarily. These are emotionally draining legal issues. They're very tough, but I thank everyone for listening for an hour and 6 minutes.
Yeah. Yep. And that's going to do it for another